Hello, everyone. Good afternoon, and welcome to the webinar, Investigating and Prosecuting the Intimidation of Victims of Sexual Abuse and Confinement. My name is Charlene Littman. I'm an Associate Attorney Advisor here at AEquitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. AEquitas has previously presented 3 PREA-related webinars: the prosecution of sexual abuse and confinement, pre-trial motions, admitting and excluding evidence in the prosecution of sexual abuse and confinement, and trial strategies for the prosecution of sexual abuse and confinement. Those webinars have been archived and can be accessed at the AEquitas website, training website, and the PREA Resource Training and Technical Assistance archived website. I apologize for that. For the best use of iLinc, I strongly recommend using our conference line, which is 530-881-1212, 202-731-738, and that you call in from a landline. That number is also located in the top left-hand portion of your screen if you need. If you're using a mobile phone, please do not use the speaker option, but listen with an earpiece if necessary. And all call-in participants have been automatically muted for the duration of the webinar. You can also connect via Internet audio on your start page. If you have any technical issues, you can use iLinc hand raise indicator, which is located on the toolbar in the top left-hand portion of the screen above the presenter's photo and to the right of the conference call number. Or you can call iLinc directly at 1-800-799-4510. Again, that number is 1-800-799-4510. Throughout the webinar, questions will be posed to all participants, which you can respond to using the iLinc feedback indicator located on the left-hand side of your screen. You can post comments or questions via private chat as well, and we will share your comments and questions anonymously with the presenter so they can be addressed during the webinar. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, and the National PREA Resource Center through funding from the U.S. Department of Justice Office of Justice Programs, Bureau of Justice Assistance. Written materials, including a copy of the PowerPoint presentation and the presenter's biographies, will be emailed to you after the presentation. As a note, via the content link in the email you received, as a reminder, you can access the PREA national standards to prevent, detect, and respond to prison rapes that are going to be addressed in this webinar presentation, as well as a link to the full national standards. The National PREA Resource Center was established through a cooperative agreement between the Bureau of Justice Assistance and the National Council on Crime and Delinquency. The mission of the PRC is to assist adult prisons and jails, juvenile facilities, lockups, community corrections, and tribal facilities in their efforts to eliminate sexual abuse by increasing their capacity for prevention, detection, monitoring responses to incidents, and services to victims and their families. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conducts legal research, provides 24/7 case consultation, hosts specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter will be AEquitas Attorney Advisor Viktoria Kristiansson. Prior to joining AEquitas, Vicky served as a Deputy Attorney General and Special Assistant to the Attorney General of New Jersey. She also served as a Senior Attorney for the National Center for the Prosecution of Violence Against Women and as an Assistant District Attorney in Philadelphia, Pennsylvania. I'd now like to turn that floor over to Vicky so that she can begin the substantive portion of today's webinar. Good afternoon, everyone, and thank you so much for joining us. I'm just going to jump right in and hit the ground running because I realize that our time together can be limited, and we want to encourage you to post comments and ask questions throughout the webinar as well as at the conclusion of the webinar. So as we all know, intimidation doesn't exist on its own. It's linked to other criminal conduct. And when a victim experiences, it's part of a larger context. It's important for us to consider the context in order to understand what we're really talking about when we're trying to analyze the offender's criminal behaviors and their full impact on the victim. So first, of course, we have to consider that sexual abuse itself within a confinement facility can feel particularly horrifying, degrading, and intimidating to a victim who is in a confinement facility. To begin to understand that devastation that a victim is experiencing, we have to consider, of course, the emotional and physical trauma that accompanies a rape. But we have to couple that with the fact that this is a rape that has occurred inside the walls of a confinement facility where a victim literally cannot escape his rapist. We've got to consider the pre- and post-incident intimidation. We've got to be looking for it to have occurred before an incident, of course during an incident, and after an incident, or a series of incidents. The abuser, the rapist, or those around him may be an expert in intimidating witnesses. This could be a long line of criminal conduct that the offender has honed and refined. He could be an expert in scaring witnesses out of reporting crimes or cooperating with authorities. The fact also that the confinement facility itself is intimidating is significant because the fear of other inmates, even other staff, finding out that you as an inmate have been, and this is the term that's often used, have been turned out by a rapist, can be suffocating and paralyzing to an inmate because once an inmate has that reputation in a prison, in a jail, in a lockup, in a juvenile detention facility, a community confinement facility, depending on the circumstances, that inmate who has already been victimized could be at risk for future attacks by others because they will see him now as someone who has been turned out. So any confinement facility certainly has the potential for intimidation. Retaliation after a report of sexual abuse at confinement. There absolutely are several persons who may potentially be unhappy about a report and may want to silence it, or may want to aid the offender in silencing it through intimidation. So why are we dedicating an entire webinar to this? I think the fact that we had more people, more criminal justice professionals sign up for this PREA-related webinar than any of the webinars that we previously have done that have discussed PREA and discussed the investigation and prosecution prison rape is no accident. I think it's because we as criminal justice professionals understand the devastating effects of intimidation on our victims and the safety, not only of our victims, but safety issues within our facility. We're sure that a lot of you are wondering how PREA actually addresses intimidation, because for the most part, we certainly as prosecutors often feel that these acts have little to do with us, but PREA does address intimidation, and in some circumstances, that could be relevant to some of the arguments that we would be making before trial. So during the webinar, we'll include some information on those standards that are related to preventing intimidation. Certainly, intimidation allows rapists to take control, do whatever they want, and think they can get away with it. It allows our defendants to evade any kind of accountability for their crimes, and then it turns facilities into exactly the opposite of what they're designed to be. It turns them into places of protection for sexual abusers and human rights violators. Intimidation hinders the investigation and prosecution of cases because we can't investigate or prosecute cases without understanding how to identify, document, and handle the effects of intimidating conduct. We all have to do a better job at understanding, recognizing, and responding to intimidation if we have any chance at stopping sexual abusers, if we have any chance at keeping our confinement facilities safe, and if we have any chance at preventing the awful effects of rape from seeping out of prison walls and into our community. We all know intimidation is happening, and we have got to do something about it. Here are today's learning objectives. At the conclusion of the webinar, participants will be better able to effectively communicate with victims and witnesses so they are able to recognize and report intimidation. And part of that is coordinating with allied criminal justice professionals so that they can also do a better job of preventing, detecting, and addressing intimidation. Analyze whether and how to incorporate intimidation into the underlying case or charge it as an independent case. And I think that over time, we certainly have struggled with that a lot. Identify statements that are subject to the Sixth Amendment Confrontation Clause, and part of that requires us to analyze whether statements are testimonial or non-testimonial and what the evidentiary implications are of that analysis. And identify conduct that may form the basis of a forfeiture by wrongdoing claim. So we're going to be able to, hopefully by the end of this, better prepare and present arguments necessary to successfully establish forfeiture by wrongdoing. So we're going to play a fact pattern now that's very loosely based on an offender and victim who were housed in Limestone County Facility in Alabama and who are featured in the documentary Turned Out: Sexual Assault in Prison. A link to this documentary is going to be included in the resource slide at the end of this webinar.
Albert Mulvann entered the Montgomery State Prison after a conviction for dealing marijuana. Although he had spent some time in a juvenile detention facility for narcotics possession and truancy, this was his first adult conviction. He was 23. Montgomery was the largest facility in the state and housed more than 2,300 males with sentences of longer than 1 year. With few exceptions, all inmates were housed together in general population. When Albert entered Montgomery, he tried to lay low, get a job, and find a small group of quiet allies. Albert was a smoker, and, as was the case with all inmates seeking tobacco, he had to engage in the inmate bartering system in order to get cigarettes. For the first couple of months, Albert was able to obtain cigarettes and repay the trade within the agreed-upon time frame. But soon enough, Albert found himself in debt to inmate Mac Burrell, a friend of inmate Simon Godoy. Simon Godoy was well known in Montgomery. He had been there for 6 years and had 11 years remaining on multiple violent felonies. Godoy was also the de facto leader of a small group of about 8 to 12 inmates, including Burrell. Albert asked Burrell to extend his debt repayment 1 more week. Burrell responded that Albert could get his ass kicked, meaning they would physically fight, or Albert would get his ass, meaning he would get raped. It was Albert's choice. Albert, fearing Burrell and his friends would beat him to death, said nothing and walked back to his cell block. Later that day, Simon Godoy came to Albert's cell. Godoy told Albert's cellmate to leave unless he wanted to get his too. Godoy told Albert that he was going to get, that it could be as painful as Albert wanted it to be. Godoy told Albert to rub Vaseline in his anus and lean over the lower bunk bed. When Albert didn't move, Godoy handed him a jar and stated he wasn't going to say it again. That day, Godoy raped Albert twice. From that point forward, Godoy raped Albert almost every day, and sometimes more than once a day. Sometimes Godoy would bring Albert cigarettes and tell Albert that he was my boy. Albert suffered pain in his anal cavity and persistent bleeding. After 2 months, he went to the prison doctor for treatment. He disclosed the rape to the doctor, and after the exam was concluded, the doctor brought in the facility's PREA coordinator and reported the sexual abuse.
So I just want to note, for those who are listening to the webinar who are not familiar with the specific PREA standards, one of the standards indicates that every facility has to have a designated PREA coordinator who can handle and who knows how to handle the reports of sexual abuse. So our first question for all of you is, did the prison doctor do the right thing? Did he do what he was supposed to do when he reported the rape to the PREA coordinator? So if you could indicate whether you believe, yes, he did the right thing, or no, he did not do the right thing, using the feedback option on your left. And Vicki, while we wait for those answers to come in, a question came in from the participants saying that you had mentioned that the inmates are housed in general population, and someone was wondering about the types of housing. Are there any studies about increased risk or occurrence of sexual assault when inmates are housed in dorms or cells? And one thing I can say is that there aren't any studies on this specifically, but there are attacks that have happened in both settings. And we hear often of cells, broom closets, etc., but also there have been abuse and homicides in prison, juvenile facilities, and dorm settings. As an example, there was a murder in New Jersey in a recent news story that occurred in a similar dorm setting as our fact pardon here in a juvenile detention facility. Yeah, that was a great question and a very complete answer. Thank you. So have we gotten a sense of whether our participants think that the physician did the right thing? The majority of participants, 25 who have answered, have said yes. No no's, 0 no's. No no's. Okay. Okay. So we would tend to think that yes, reporting a rape is the right thing. And I just want to point out a couple things. First of all, we need to look at our PREA standards, but at the same time, we also have to look at a physician's duty as far as patient privacy and confidentiality. And it can depend on state laws, but in this case, the physician did need Albert's permission to report the sexual abuse. There are some exceptions that are statutory exceptions, and they're certainly state-specific. And there are examples like Pennsylvania and Maryland where a physician can or should report an injury that is caused by a crime that's committed with a weapon. But here, based on what we believe Albert and what we know at this point, Albert disclosed to that prison physician, again, depending on state reporting laws, as far as patient privacy and confidentiality, the doctor would not have been able to report it without Albert's permission. It's very possible, and this goes back to the issue of ensuring that every one of us, and when I say every one of us, I mean any allied criminal justice professional who is part of potentially responding to one of these cases, we've got to have the proper training. And this is certainly a case where the prison doctor may not have understood his legal and ethical duties. He may have thought that he was supposed to report this. There is a relevant PREA standard, and perhaps the doctor here would have gotten it confused. It's PREA standard 11561, and it's about staff and agency reporting duties. And essentially what this PREA standard says is that all staff have to report immediately any knowledge, suspicion, or information regarding an incident of sexual abuse or sexual harassment that occurred in a facility, whether or not it's part of the agency. They also have to report any retaliation, and they also have to report any staff neglect or any staff violation of responsibilities. So PREA is significant in that there's at least minimally going to be an internal report so that the facility will be aware when something has happened. But at the same time, the victim's ability to choose to participate in the criminal justice process will be protected. So the PREA coordinator asked Albert what happened, and Albert, believing he had to answer the question, provided a general account of his victimization. The PREA coordinator called the shift supervisor and told him to execute the required staff first responder duties. Separate the alleged victim and abuser, preserve and protect any crime scene, And if the abuse occurred within a time period that still allowed for the collection of physical evidence, request that the victim and abuser not take any actions that could possibly destroy physical evidence, including, as appropriate, washing, brushing teeth, changing clothes, urinating, defecating, smoking, drinking, or eating. And obviously, in terms of investigating and prosecuting this incident, and certainly any incident of sexual abuse in a confinement facility, knowing what the first responder duties and determining whether or not they were actually executed would be significant in an investigation and prosecution of a case. What should the prison do as an initial response? So let's assume that the facility has just learned, obviously, through the report of the doctor and the notification of the PREA coordinator that this has occurred. What should the prison do initially with Simon Godoy? A, tell Godoy he's been accused of rape and therefore is being moved to another pod within the prison, so another area within the prison. B, tell Godoy he's been accused of rape and therefore is being moved to solitary confinement. C, transfer Godoy to another prison with no explanation at all. Or D, interrogate Godoy in the prison administrative offices and transfer him to solitary confinement. So please indicate which letter you think is the most likely using the feedback option on your left. And I will say, in terms of C, I'm transferring our defendant to another prison with no explanation at all. You'd assume that even if there initially was no explanation, very soon he would know about it because he would be questioned by investigators. Charlie, did our participants respond?
Yes, our participants have responded. The majority of responses were D, with the next highest being B, and then A, and there's very few selecting C.
Okay. And really what is interesting to note is that PREA doesn't have a required response. Any of these things actually could happen. And this is one of the reasons that we encourage jurisdictions and we encourage professionals to have open communication about what would happen so that prison officials understand really how to apply PREA and how their decisions will affect investigations and prosecutions. And we really need to make sure that a lot of the decisions that we're going to make will be focused on keeping Albert safe, of course, and that we're complying with PREA in keeping Albert safe, but not moving Albert, not moving the victim to a place in a confinement facility where he could perceive it or in actuality it could be punitive. In other words, let's try to focus on the transferring of the offender when it's appropriate rather than punishing in some way Albert, unless that would be the best case to move Albert. And directly related to responses and keeping our victims safe, Charlie earlier mentioned that we had done a few other webinars on PREA, and there's one that could be particularly helpful that's focused on pretrial motions. So I would suggest if you're looking at some ways to increase victim protection, pretrial particularly, you listen to that webinar. Assume Simon Godoy is a staff member. So assume our defendant is a staff member who committed this long-term sexual abuse. What could the facility do upon receiving a report of sexual abuse perpetrated by a staff member? A, immediately suspend him. B, suspend him pending the outcome of an investigation. C, reassign him to desk duty only. Or D, transfer him to another prison. Please indicate which letter using the feedback option to your left. And it looks like, Vicki, as the numbers keep coming in, that B is the very strong first place, with just a few choosing C, A after that, and 0 D so far. Okay. And really the guidance that PREA offers is that neither the agency that's in control of this particular corrections facility or any other government entity responsible for collective bargaining on the agency's behalf can enter into or renew any agreement that limits the agency's ability to remove staff abusers from contact with inmates pending the outcome of an investigation or pending the determination of whether and to what extent discipline is warranted. So regardless of whether our offender is an inmate or a staff member, upon a rape report, a facility can and should, at a minimum, ensure there's absolutely no contact. So not just immediately as part of that first response, but on a continued basis. And some of this can be found in PREA Standard 115.66. And again, we're going to provide all of these standards to you at the conclusion of the webinar. So a SART is designed, as many of you most likely know, a sexual assault response team, a SART, is designed to ensure that all responding pieces are in place and available options for the victim. And the PREA standards provide for healthcare advocacy and law enforcement. In terms of healthcare, the standards provide that it can be provided for immediately and at no cost to the victim. And a sexual assault forensics exam should be performed specifically by a SANE or a SAFE, a sexual assault forensic examiner, if those professionals are available. And in reality, a victim could receive immediate medical care at the facility in which he or she is housed and then be transferred to an outside facility for an actual SAFE exam. In terms of advocacy, PREA requires that inmates be provided with access to a confidential advocate, independent from the facility if possible. And this is very, very significant, particularly when we're talking about intimidation, because we know from the research that has been done on intimate partner violence, and so certainly you would assume that the same would be true in these situations, that victims who are supported by an advocate, who have a relationship, who receive services from an advocate, are better supported, more likely to stay on board, and have greater resources. And what does that mean for all of us? That even if there is still intimidation present, that the other pieces will be in place to prevent it from happening again, and also to provide the support that the victim needs. So PREA allows that there is a confidential advocate independent from the facility if possible, and if that's not possible, the facility is required to select and train an internal staff member. And for law enforcement, as part of a SART, if the victim wants to report to law enforcement, a designated responding agency, whether it's state police, county detectives, the county prosecutor's office, municipal detectives, or other, will respond and conduct an investigation. But really the bottom line in all of this, if we're talking about ensuring victim health, is ensuring victim safety. We've got to keep Albert safe, and we do all of this to keep him safe and to support his healing. Because we know if we fail to do these things, he will be in no position to participate in the investigation and prosecution of Godoy. And of course, what is absolutely crucial in terms of maintaining safety is that we prevent and respond to intimidation. We know its impact is significant. It's so crucial that we prevent it and appropriately respond to it because the impact is significant. We've got physical and emotional injury to our victim. Intimidation increases and creates additional fear for the victim. The victim may feel that he just has to comply with whatever the offender does, lest he suffer additional harm. And imagine feeling that way even after you've made a report to law enforcement. The failure to report it means that, it has worked. It means the victim has a legitimate fear of the offender and or others, and the victim believes that the system won't help him. And finally, intimidation may open the door to the offender victimizing others. So this begs the question, what do facilities already have in place to prevent intimidation and retaliation? Well, certainly we've already discussed a couple of those things, but here are some of the other
very relevant PREA standards, and I'll just briefly mention what they are. The first one, 11513, is a prevention planning standard that requires an agency to develop and document a staffing plan, staffing levels, and this is important for investigators and prosecutors, where applicable, video monitoring. And why is this significant for us? Because even if it doesn't capture the sexual abuse itself, it certainly can capture the actions and behaviors of the offender or his associates or the victim before or after the assault. So this is an extremely significant one. 11541 essentially says that during intake screening, all inmates have to be assessed for the risk of being sexually abused by other inmates or being sexually abusive toward other inmates. So hopefully what this means is once facilities have implemented PREA and implemented these standards, that we're going to see eventually a decrease in our level of sexual abuse inside facilities. 11543 supports what we talked about in the previous slide, that inmates at high risk for sexual victimization should not be placed in involuntary segregated housing. And essentially it says that that can only happen when there is really no other available alternative means of separation from likely abusers. 11551 provides multiple internal ways for inmates to privately report sexual abuse and intimidation, as well as staff neglect or violation of responsibilities that may have contributed to the incidence of sexual abuse. 11554 requires agencies to establish a method to receive third-party reports of sexual abuse and publicly distribute the information on how to report abuse on behalf of an inmate. 11561 we discussed earlier, and that's all staff has to report ASAP if they're even suspicious that sexual abuse is occurring. And 11566, there is going to be no agreement at all that limits an agency's ability to remove an alleged staff abuser from contact with inmates, pending the outcome of an investigation or even a disciplinary determination. There are also sanctions. The agency has to have a policy in 11567 to protect all inmates and staff who report sexual abuse or cooperate with investigations. 11576, staff who violate will be subject to disciplinary sanctions, and this is really, really significant. And simply because as I was reading this standard, I reminded of cases, and we've all been there, when we're in court and we're arguing anything ranging from bail to other pretrial motions, and we hear the defense talk all the time, well, Your Honor, he's going to lose his job if we do this. And what's significant here in this standard is that termination. This standard says termination shall be the presumptive disciplinary sanction for a staff member who has engaged in sexual abuse. 11578, inmates should be subject to disciplinary sanctions following an administrative finding that the inmate sexually abused another inmate, or following a criminal finding of guilt for sexual abuse of an inmate. So even in cases where an inmate is not reporting to outside law enforcement, there could still be internal disciplinary sanctions. Responding to intimidation, here's what we all really have to do. Practically speaking, if we're going to try to prevent it, but also make sure that our victims recognize it, because if our victims don't recognize it, they don't know how to safely report it, and if they're not safely reporting it, we can't prevent future acts of intimidation from occurring against them. And then, of course, we certainly can't investigate and prosecute them. So first, we've got to recognize the issue ourselves as significant and as pervasive. We've got to be going into these cases looking for it. We've almost got to assume that it's going to occur, and so we've got to be having those conversations ASAP and letting the victim know what to do about it. Support our victims by communicating with our victims so that they can recognize all subtle acts that constitute intimidation. Because often, we're conditioned by the media to think of intimidation as acts that necessarily, for example, include a gun or a threat with a gun, or the only acts that ever hit the news, somebody walks into a store where a witness is working and shouts and threatens them and doesn't even have to show the gun, but is holding something in their waistband. In fact, what we know from the research is that acts of intimidation are much, much more subtle. And so if we're not taking the time to explain these subtle acts to the victim, then the victim won't be able to report them to us, especially in the case of Albert, where he has been victimized by Simon Godoy for so long. He might accept that this intimidating conduct is just part of what life in prison is about. And he needs to know that he really should be reporting to us, and we've got to give him a safe way to do it. We've got to create some kind of plan so that he knows how to do it and to whom to report it. And really, we should give him more than one option. Beyond that, we've got to train law enforcement to properly investigate it and to document it in a manner that any other part of a criminal investigation would be documented accurately and thoroughly. And finally, we've got to prosecute it. We've got to follow up on it, and we've got to punish our offenders for it. We've got to do something about it. We've got to have a plan in place so that all of our team members, our prison staff, our Department of Corrections investigators, outside law enforcement, and any other relevant agency or persons know about it so that we can actually prosecute it. Part of that is having a safety plan, and safety plans are crucial for victim survival, and they should exist at a number of levels for a victim who is incarcerated to make sure he has maximum protection. Ensure there's a court order for separation and other protections if necessary. So these should be in place anyway, but if there is a fear that perhaps something isn't happening as it should be inside of a facility, then absolutely we should be having judicial orders signed. There should be extra protection. And for examples on safety plans, there are certainly many out there. I would suggest, and we have listed in our resource slide at the end, looking at RAIN. You can contact the PREA Resource Center. You can contact us. But you've got to develop a plan, obviously, that's specific to incarceration, including a safe place, a person who can help, where to go, and that plan could possibly include relocation. As we've mentioned, we've got to have accountability on both levels, both internally in terms of the correction system itself and, of course, the criminal justice system. Okay, preliminary hearing. Simon Godoy is charged with multiple counts of rape and related charges. 3 weeks later, Albert testifies and is briefly cross-examined by the defense attorney at the preliminary hearing, and the case is held for court. Prior to trial, Albert writes the prosecutor a letter stating he does not want the case to move forward and he does not want to testify at trial, and he asks to be left alone. At this point, can the prosecutor try the case without Albert? So just with the facts that we know and considering who our potential witnesses are at this point, is there any way we can prosecute this case without Albert? Please answer yes or no using the feedback option on your left. And this is just quick, guys. Go with your gut. What do you think, yes or no? Charlie, do we have responses?
So far, yeah, sorry about that. As it looks so far, about 88% have said yes, with just a little bit of 12% saying no.
Okay, 88% said yes. Wow. For those of you who said yes, if you want to chat some of your reasons to Charlie and she can share them anonymously. It would be great to hear why you think yes. I think the issue here is that we really don't know at this point. We really don't know the answer until we know all the facts. So in terms of analyzing this, how would we be able to establish the actual elements of the rape?
Vicki?
Without Albert. Yes.
One response that we got from our participants was that there may be enough physical evidence from the doctor's exam.
And that's certainly something that we should be looking into. But what do we know from the studies that are out there in terms of what, if any, injuries we have after a patient presents with a history of sexual assault? And generally speaking, and I'm going to be speaking very, very generally, simply because I'm not a sexual assault nurse examiner or a physician, so I'm going to be speaking very broadly. But what we know is that for the most part, and I'll start with our female patients because there is certainly much more research on female patients who present with a history of rape than male patients, that in the overwhelming majority of cases we're not finding anything. And what we also know is from the limited research that is available on male victims, there is more likely to be injury to the anal cavity. So you're going to find some kind of injury more often in a male victim who presents than a female victim who presents with a history of a vaginal rape. However, I think it would be difficult to establish, even based on the injury, that this was due to a rape. And I would be really, really interested in hearing from anybody who wants to add to that.
Another comment that just came in, Vicki, was physical evidence, video surveillance, inmate statements could support probable cause or maybe even support a lower charge. And this goes on to the belief that the facilities have a duty to protect all inmates and promote that zero tolerance rule.
Yes, this is absolutely right, and that's a very good comment. So you certainly want to start to look into other options and figure out what, if anything, we can do to be holding Simon Godoy accountable. And of course, we only know some limited facts at this point, but we've got to start considering which of our statements are hearsay statements, which are going to fall under Crawford, which are going to be testimonial and non-testimonial, and then we want to think about why we got that letter from Albert. So our first step in our analysis is Crawford v. Washington and its progeny. And the next 10 or 12 slides are what prosecutors need to know in terms of analyzing statements and the evidence for purposes of admissibility, particularly when the victim or witness will be unavailable at trial. And this is important information for all of us, not just prosecutors, because we all need to be thinking about what we need to be gathering in order to get these cases to trial. Think of this information, the case law, et cetera, in the context of always being conscious of preparing for the possibility of intimidation and being diligent about documenting and collecting evidence. And also think of the necessity, again, of clearly explaining the relevant signs and behaviors related to intimidation so the victim knows it when he sees it, and then he can report it and we can do something about it. So part one. The cases that really started it all, and these began in 2004. So Crawford tells us that essentially in all criminal prosecutions, it's a Sixth Amendment case, the accused shall enjoy the right to be confronted with the witnesses against him. And Mr. Crawford stabbed a man who allegedly tried to rape his wife, Sylvia. Mr. Crawford was charged with assault and attempted murder, and what did defendant Crawford do? He claimed, drum roll, self-defense. At trial, he invoked the state's marital privilege. And by doing that, he prevented his wife, Sylvia, from testifying at trial. And in response, the state introduced Sylvia's recorded statement as evidence that the stabbing was not in self-defense. The trial court admitted Sylvia's statement because it had sufficient indicia of reliability, and Washington State Supreme Court upheld the conviction. However, the United States Supreme Court, and Justice Scalia authored the opinion, agreed with defendant Crawford's argument that admitting the evidence would violate his right of confrontation under the Sixth Amendment. And essentially what Crawford tells us is where testimonial statements are at issue, only confrontation satisfies. This is a great chart that was created by Jessica Smith of the University of North Carolina School of Government. And it really breaks down testimonial, non-testimonial. But the bottom line is, if a statement is testimonial, the reliability can only be tested two ways. One, cross-examination of the witness. Or, if the prosecution shows that the declarant is unavailable and there was a prior opportunity to cross-examine the witness. So we've got a straight situation where the witness is available and is being cross-examined, or if our witness is unavailable, there has to have been a prior opportunity being the big word, to cross-examine the witness. If it's non-testimonial, if the statement is non-testimonial, it's not covered by the Confrontation Clause, and it's left to the state to decide admissibility. Of course, Crawford left for another day any effort to comprehensively tell us what testimonial statements were, but we had help 2 years later in the Davis and Hammond cases. Those were both domestic violence cases that were decided together. In Davis, the victim called 911 and the defendant had just left the scene when she called. The Washington State Supreme Court, again we were in Washington, affirmed the holding that the 911 call was not testimonial because the purpose was to call for help, not to bear witness. And the Supreme Court said, okay, that's correct. We're affirming that was not subject to the Confrontation Clause. In Hammond, the police responded. The defendant was in the kitchen, and law enforcement questioned the victim in another room. So they separated the victim, the offender, and they questioned the victim in another room. At trial, when the victim was unavailable, her statements to police were admitted into evidence, and the Indiana Supreme Court said those statements were non-testimonial because the purpose of her statements were to assess and secure the situation. The Supreme Court said, no. By the time police secured the room and separated the victim and the defendant, the emergency was over. So Davis and Hammond clarified that police interrogation, police questioning, is testimonial if circumstances objectively indicate there was no ongoing emergency and the primary purpose was to establish or prove past events potentially relevant to a later criminal trial. It's non-testimonial if circumstances objectively indicate there was an ongoing emergency and the primary purpose was to address that emergency. So the primary purpose we've got to try to establish was to end a threatening situation. And what would be relevant facts here? Well, a threatening situation not just to the victim, but to the police and to the public. Michigan v. Bryant. In this case, police responded to a radio dispatch of a man who was shot. The victim said the defendant shot the victim outside of the defendant's house, and then the victim drove himself to the gas station parking lot. Police found him there with a gunshot wound to the abdomen. He was in great pain and had difficulty speaking. They asked him what happened, who shot you, where did the shooting occur. He gave them that information. He gave them the shooter and the circumstances. And then the victim died at the hospital within hours. At trial, officers testified to what the victim said in that gas station parking lot. And here, the court said the victim's statements were not testimonial because the primary purpose of asking those questions and getting the information was to enable police to meet an ongoing emergency. And thus, of course, this was not subject to the Confrontation Clause. Michigan v. Bryant did these four things. They reaffirmed the primary purpose test from Davis. So when the primary purpose is to address an emergency, we're not creating a record for trial. The statements are non-testimonial, and they're not within the scope of the Confrontation Clause. The court directed the use of an objective evaluation of the case circumstances to determine the primary purpose of the statement. So assess objectively from the perspective of parties at the time of the encounter. In other words, would a reasonable person believe there was an ongoing emergency at the time? Explain that the objective evidence of the primary purpose of the interrogation comes from the statements and actions of both the declarant and the interrogators and the questioners. And finally, clarify that the existence of an ongoing emergency is among the most important factors to consider, but not the only factor to consider. So where do we go from there? How do we analyze our statements? AEquitas has created a fabulous resource. It's called the Prosecutors Resource on Crawford and its Progeny. We attached a link to this resource at the slide, in the slide at the end of this webinar, and you can go onto our website and get it. And this slide, this chart, and that resource hopefully provides a lot of guidance for analysis of statements. But we know that testimonial statements are those made under circumstances that would lead an objective witness reasonably to believe that the statements would be used later at trial. And there's some difficult categories there. There's some situations where subjectively, meaning an individual's perception, a declarant might reasonably expect that his or his statement would not be used later at trial, and others where objectively a person might assume the statement would be used later at trial. An example is 911 calls. Conversations that begin as non-testimonial could evolve into testimonial conversations, including testimonial statements, once the need for that emergency assistance has been met. And certainly, what can we do as prosecutors? We're not giving up the 911 call. We can redact those statements that are deemed testimonial. We can exclude those statements that are deemed to be testimonial. Albert testified at the preliminary hearing and was cross-examined by the defense attorney. If he was unavailable at trial, would his preliminary hearing testimony be admissible at trial? Let us know if you think yes or no. And guys, as you're thinking about this, is his preliminary hearing testimony testimonial? And let's go through this analysis. Yes, it is, so it's subject to Crawford, and we'd have to do an analysis. Was there an opportunity for full and fair cross-examination at that prelim? That's what we would have to do as prosecutors. We would have to provide the full and fair opportunity for cross-examination. Again, operative word being opportunity. Full and fair opportunity for cross-examination at the preliminary hearing. But what is the purpose of our webinar today? To talk about intimidation. So our next question, our next analysis would be to depend on what caused the unavailability. So Charlie, tell me, in answering this question, did our participants think yes or no?
About 73% said yes, with 27% saying no.
Okay. And really, guys, it depends. It depends. If there was no intimidation, and this is what we're going to get to right now, if there's no intimidation, we would need a full and fair opportunity for cross-examination at the preliminary hearing in order for that testimony to be admissible. However, if Albert's unavailability is due to intimidation, perhaps his preliminary hearing testimony would be admissible at trial without Albert through forfeiture by wrongdoing. This is what we're talking about today. But remember, before we move on, if the statement is not testimonial, Crawford doesn't apply. So our first question has to be, is it testimonial or non-testimonial? But at the end of the day, our state hearsay rules still do apply, and the statement has to fall under an exception. So Crawford wouldn't apply, obviously, if the witness testifies. It doesn't apply in civil proceedings. It doesn't apply at sentencing, probation, revocation hearings. There's many situations where it doesn't apply. But let's talk about non-participating victims and establishing forfeiture by wrongdoing. So after the preliminary hearing, Albert returned to the prison. And the staff member who conducted his pat-down told Albert that he had caused a lot of trouble for everyone in the prison and that Albert was going to get him. When Albert returned to his cell, there was a note on his prison, "Watch out, my boy. No one is looking out for you now. So recall that earlier slide. Albert wrote the prosecutor a letter stating he didn't want to testify at trial. So earlier, that's all we knew. We knew about this letter because we had received it as the prosecutor. And in response, let's assume that the prosecutor is going to schedule either a phone call or a prep session with Albert, and Albert discloses this, that after the prelim this occurred. He has this note. So what does this mean, guys? This means now we know why Albert is refusing to testify. What can we do about it? Here's what we can do. Forfeiture by wrongdoing. It's about intimidation. Intimidation is all about avoiding in-court confrontation. And we've got to do it. We've got to be working towards this if we have the support, if we have the evidence, because it benefits the victim, the community, our confinement facilities. It benefits everybody. Here's where we can find it. In the federal rules, we can find it in 804. So 804 gives us examples of when a witness is actually considered to be unavailable. And then in B6, it tells us if the declarant is unavailable, and in our case, that would be Albert. If the declarant is unavailable, a statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability and did so intending that result. That would be Simon. Forfeiture by wrongdoing, clearly an invaluable tool, and it applies to any potential witness who is unavailable. So what do we know about the examples that are included here? This could be a witness who refuses to testify, who claims lack of memory, who fails to appear, who is dead. And forfeiture by wrongdoing opens the door to any hearsay. Reynolds, the 1878 case, so there is a significant history to the idea, to the concept, to the strategy, to the right of forfeiture by wrongdoing. The Constitution gives the accused the right to a trial at which he should be confronted with the witnesses against him. But if a witness is absent by his own wrongful procurement, he cannot complain if competent evidence is admitted to supply the place of that which he has kept away. The Constitution does not guarantee an accused person against the legitimate consequences of his own wrongful acts. If he voluntarily keeps the witnesses away, he cannot insist on his privilege. If, therefore, when absent by his procurement, their evidence is supplied in some lawful way, he is in no condition to assert that his constitutional rights have been violated. Same case. This concept, this idea, dates back to 1878. It remained untouched in the case law. The Roberts test, and that was the 1980 case, U.S.C. Roberts, is very different from exceptions to the Confrontation Clause that make no claim to be a surrogate means of acceptable reliability. For example, the rule of forfeiture by wrongdoing, which we accept, the court tells us in parentheses, which we accept, extinguishes confrontation claims on equitable grounds. It does not purport to be an alternative means of determining reliability. So reliability is no longer the test. That's what we know. And we also know that 1878, 2004, the court is still saying we accept forfeiture by wrongdoing. They did it again in Davis. We reiterate what we said in Crawford, that the rule of forfeiture by wrongdoing extinguishes confrontation claims on equitable grounds. One who obtains the absence of a witness by wrongdoing forfeits the constitutional right to confrontation. How has the Supreme Court analyzed forfeiture by wrongdoing in modern times? Here's a big case, and certainly important for all of us to know. Giles v. California. This was a domestic violence-related homicide where the defendant shot his ex-girlfriend. Once again, we saw a claim of self-defense, and as part of that claim, he said that there had been prior bad acts, that the victim had threatened him and his new girlfriend, that the victim had charged at him, and that he was afraid, in this case, that she had something in her hand, and that because of this fear, and because, of course, he just happened to have a gun, he closed his eyes and fired several shots, and he didn't intend to kill her. He asserted this in spite of the fact, I'll note, that at trial the ME testified that at least one of those 6 shots occurred after the victim was already on the ground, at least one of them. Notably, 3 weeks prior to the homicide, there was a domestic violence incident. The victim called 911. She was crying. She made statements about being assaulted, about being strangled, and being threatened with a knife. Those statements were then allowed in under forfeiture by wrongdoing based on the defendant's intentional act of killing her. And the defendant was convicted of first-degree murder. That conviction was affirmed by the California Supreme Court. And then it went up to the United States Supreme Court. And while that appeal was pending, Crawford was decided. And here's what happened. The case was actually remanded. The court said there was not enough evidence that the victim was made unavailable due to the intentional act of the defendant. And the defendant had to have specific intent to make the victim unavailable as a witness when he committed the wrongdoing. So the court essentially told us that in order for forfeiture by wrongdoing to apply, we, the government, has to show that the defendant caused the witness's absence with the purpose of preventing her testimony. I will note that in the dissent, Stevens, Kennedy, and Breyer did write that the defendant's knowledge that killing the victim would have made her unavailable should have been enough to fulfill the requirement. And also, before we move on, just because I think so often we hear about these decisions, but we don't know what actually ended up ultimately happening in a case that goes back. And I just want to let everyone know that Giles, the defendant, was retried, and he was reconvicted. And, of course, he appealed, but the case was upheld, and that opinion is unpublished, but the case was upheld. And I will also say notably that on that retrial, there was no forfeiture by wrongdoing evidence introduced at all. So our question for you, can the prosecutor use a letter as evidence in a forfeiture by wrongdoing hearing? And when we're saying the letter, we're talking about that note that was left on Albert's pillow. Can we use that note as evidence in a forfeiture by wrongdoing hearing? So let's assume Albert is unavailable at trial. We know the facts that we know. Can I use the note? So let us know what you think, yes or no, and if you want to tell us why you think yes or no.
And Vicki, while we're waiting for those results, I just wanted to let you know that we have a question about how can a community-based advocate provide support or tools to victims to help with possible prosecution?
So to provide support for victims in confinement?
I'm assuming that's the question, yes.
Yeah. That's something I would be more than happy to talk to you about afterwards. But from what we are understanding is that our facilities, all of our confinement facilities that are complying with PREA, and even some who are officially not, are required to provide access to confidential advocates. And most of the facilities are doing the following. They're contacting either their local rape crisis center or the umbrella organization in their state. So in Pennsylvania, for example, a confinement facility could contact a local rape crisis center or the Pennsylvania Coalition Against Rape. And through the contact, they're creating and they're signing MOUs, Memorandum of Understanding, so that the advocates get special training on perhaps what would be different about providing the care in a confinement facility. And the confinement facilities are trying to do things like, first of all, have a hotline available for anonymous reporting, and they're trying to figure out ways to ensure that there is access. And that can be provided in a number of ways. On the phone, certainly in writing, certainly through counseling sessions that are both individual or group. But this is something that, thankfully, due to PREA, facilities are working on a lot right now. And again, I certainly encourage you to contact us afterwards. Tara, if people can hear you, if you want to chime in as well, or certainly we can provide additional information after the webinar on this. Charlie, can we hear Tara?
Unfortunately, I don't think that we can.
Okay.
Well, I'll get that working so that she can. Just so you know, about 81% of participants, going back to the question, answered yes, and about 19 said no.
Okay. And, I mean, this is, our challenge here really would be to connect that letter to the defendant or to one of his associates. And what's really helpful is that he said, my boy. I mean, remember in the beginning, we noted in the fact pattern that Simon began to refer to Albert as my boy. And the fact that he put that in the note would be extremely helpful in tying him to writing that note. So we would have to connect the letter to Simon or one of his associates. And I want to just take a minute to note that all state statutes do not cover necessarily conduct that a defendant acquiesced in causing. So you'd have to check your specific state statute and the case law. But the answer really would be yes, if we could show that the letter was intended to cause Albert's unavailability at trial. That's what we've got to connect here, that the intimidating conduct is designed to prevent Albert from testifying at trial. Can the prosecutor use the statement of the staff member who conducted the pat-down as evidence in a forfeiture by wrongdoing hearing? And remember, guys, that staff member said Albert had caused a lot of trouble for everyone at the prison and that Albert was going to get his. Can we use that statement in a forfeiture by wrongdoing hearing at trial against Simon? Charlie, what are people saying? Yes or no?
As the numbers grow, we're looking at, again, about 88% saying A, with 6%, 11% picking D, and yes or no, I apologize for that. About 89% saying yes, with about 11% saying no.
So, of course, guys, this is a letter that's designed to intimidate Albert. But in terms of connecting that letter to Simon, connecting those statements and that behavior to Simon, that would be our challenge there. Because remember, that right is attached to Simon. It's attached to Simon. So we would have to be able to show that that was intended to cause Albert's unavailability at trial, and it was connected to Simon in some way. So that would be our challenge there. It might be relevant otherwise, but as far as Simon, considering that it's based on the evidence we have at this point, Simon was not aware that the staff member said those things during that pat-down. It would be difficult. So what is our burden of proof? The burden of proof in most jurisdictions is preponderance of the evidence. And it applies to any and all potential witnesses. There doesn't have to be some formal proceeding underway. And we can use the hearsay statements themselves. So all of that would come in. Examples of what comprises wrongdoing. These are what the courts and the cases have held so far. Significant influence, including influence and control. Knowledge, complicity, planning, or in any other way. Evidence of past relationships is relevant, but may not be enough by itself. And that reminds us of Giles, that we would need to be able to show a little bit more. And there have been a lot of cases. some of our attorney advisors, Rhonda Martinson, John Wilkinson, did a lot of research connected to forfeiture by wrongdoing, and we have a lot of cases that have supported this. And examples of conduct would be disabling a witness's car, using a civil suit to coerce a victim, following a victim, blocking a victim's car, making embarrassing photographs of a victim, killing a witness's livestock. That was a 2010 case out of Michigan. Making a throat-splitting motion to a witness, and certainly that's something that, unfortunately, many of us, particularly those of us who have handled domestic violence cases, might have experienced before, gang cases. Accepting a bribe to help a man make a false confession, calling a number of times. There was a 2010 Missouri case where there were over 200 calls made to the victim, and those calls themselves were considered witness tampering. So there are certainly a lot of examples of what comprises wrongdoing. What other evidence can investigators and prosecutors look for to introduce in a forfeiture by wrongdoing? And I'm really asking because I'd like all of you to think about cases you've had. If anyone participating in today's webinar has done a motion to introduce a victim's or witness's statements through forfeiture by wrongdoing, and what happened in that case, what the circumstances were. And I know Charlie indicated that somebody had asked about the totality of the circumstances in terms of arguing and proving that or connecting conduct to the defendant. And absolutely, you would want to argue totality of the circumstances, but the bottom line is the burden, that we've got to be able to connect the conduct to the defendant or the defendant's associate. The right is specifically the defendant's, that confrontation right. So we've got to be able to connect the conduct to him. That's a good question. Charlie, did anybody indicate that they had done a forfeiture by wrongdoing hearing?
Sorry, it took a second to cut off. Unfortunately, we don't have any responses just yet on those, but do keep them coming if anyone has any comments or questions or responses about the forfeiture hearing.
Okay. And certainly, guys, what we see in intimate partner violence cases, we see all the time that there are threats, whether direct or indirect or subtle, about child custody and payment and finances and homes. And these are all things that in our intimate partner violence cases, so many of our victims are used to this conduct that they do not recognize it as intimidation. And in fact, the courts have said that it is. And so these are the things that we would want to know about from our victims. And we want our victims to know that this is intimidation, and we want them to know how to safely report it to us, so that if they did get to the point where they said, I'm not available, I'm not coming, or they felt they safely couldn't be available, we could use that evidence in a forfeiture by wrongdoing hearing. And the other thing I wanted to point out is that these motions, these hearings, do not have to occur prior to the commencement of trial. There have been cases where defendants or defendants' associates have intimidated witnesses after the trial has started, and certainly during witnesses' testimony. And there have been forfeiture by wrongdoing hearings in the middle of trial. And then at that point, all of those hearsay statements can come in to evidence. So here are some promising practices as we're getting ready to wrap up the webinar. We've got to have a coordinated response. And that really means all of us recognizing intimidation as a crime, preserving the evidence of intimidation, reporting it, and educating our victims. We've got to maintain our physical evidence. So the victim's report, physical evidence, photographs, videos, diagrams, document any and all injuries as soon as we find out, as well as over time, because we know that some injuries are not apparent within a short period of time after an assault, but are apparent later, or it might get worse later. We have got to get our medical records for both the victim and the defendant and look for social media and online evidence, even when it comes to cases in confinement. You never know. We've got to do all this so that we can establish probable cause that additional crimes were committed. We can get to the point where we can prove the crime in a court of law with or without the victim's testimony. Obviously, regardless, we want to strengthen and corroborate our cases and document the circumstances around all statements and disclosures that we've received. So who are we going to look for? We're going to look for relatives. We're going to look for other inmates, other staff, cellmates. That's really what we mean by neighbors. Our cellmates and our neighboring cellmates, and perhaps visitors, including children and families who might know something, who might have heard something from the victim or somebody else. Written recorded statements, confessions, admissions, witness statements, victim statements. And we want to ask the victim, did you talk to anybody else about this before or after you spoke to the police or before or after you spoke to the doctor? Document any evidence that establishes or supports that any statements were made in the context of an emergency so that they're not testimonial and thus not subject to Crawford, et cetera, et cetera. Another promising practice, of course, is having a specialized unit. And in so many prosecutors' offices that are smaller, this might not be possible. But a best practice is to have vertical prosecution. And if you don't have this in your office, try your best to pull a case out for vertical prosecution. So if you have this case early on and you know that this is a case that needs a lot of attention and the victim needs support, pull it. Specialized units are also really helpful because of concentrated trial experience. Prosecutors share information, and then they can improve their relevant trial skills and share strategies. We can, of course, need to be collaborating with criminal justice professionals, and none of us does this alone. None of us does our job working on these cases alone, especially prosecutors, and have focused training. We've got to gear our training towards the need of the specialized unit, and it has to include information on intimidation. At our preliminary hearings, our best practice is to foster a full and fair opportunity for cross-examination. So put that on the record, guys. Put it on the record. Put on the record that you are providing a full and fair opportunity for cross-examination. Fight defense attempts to waive a preliminary hearing. Pass discovery before the hearing and put that on the record too. Say at the prelim, for the record, I passed complete discovery on X date, and I am providing defense with a full and fair opportunity to cross-examine the witness. At any hearing, allow short adjournments because that minimizes intimidation, and try not to object because fewer objections indicates full and fair opportunity for cross-examination. Okay, can we introduce evidence of intimidation in our case in chief? In this case, in our case against Simon Godoy, can we introduce the evidence we have of intimidation? That note, for example, in our case in chief. Let us know using yes or no. Charlie?
Yes, as the answers are still coming in, the majority is yes with just, 6%, one response of no so far with 95% yes, 6% no.
Yeah, so we're looking for the defendant's state of mind, consciousness of guilt, admissions. We can also consider charging as part of an ongoing course of criminal conduct. We can, of course, consider charging as a completely separate case. And several jurisdictions have helpful case law related to this, but one I wanted to note is a Connecticut case from 2012, State v. Thompson, 45 A3rd 605. And anybody who didn't get the site can certainly email us after this. State v. Thompson, 45 A3rd 605, Connecticut 2012. And here, the evidence of intimidation was introduced to explain the witness's unavailability the evidence of the defendant's mens rea, and the evidence of his consciousness of guilt. And the judge in this case said generally uncharged conduct isn't admissible, but when that evidence shows through the misconduct that there was an intent to obstruct justice or avoid punishment for the crime charged, it can be admissible. What is very important for all of us to remember is our jury instructions. And here, the trial court gave 2 limiting instructions on the use of that evidence of the defendant's involvement. That was a murder case in the witness's murder. But we have got to be very conscious of our jury instructions when we're going to be introducing and using evidence. So a recommended practice in conclusion, we've got to be proactive to encourage our victim cooperation in these cases. We should work with a coordinated multidisciplinary team response because we know that will increase victim cooperation. Provide the victim with resources and services that make the victim feel safe and secure throughout the duration of the investigation and prosecution and after trial. Communicate about, prevent, and respond to intimidation, and that includes considering forfeiture by wrongdoing and using it when it's applicable, and opposing delays and continuances, strenuously objecting to those. Some of the resources that we mentioned during the webinar are available on this page, but I really want to encourage everybody to please feel free to reach out to us. At AEquitas, we provide assistance for free 24 hours a day, 7 days a week. And if you want additional information on PREA, I think specifically for the question that was raised before about advocates, the National PREA Resource Center and Tara Graham, who's on this webinar today, has a lot of information about some of the practices that are occurring across the United States, what some confinement facilities have chosen to do, and some of the things that have and haven't worked for them in terms of being able to link inmates to advocates confidentially and to anonymous reporting and also to reporting to law enforcement. Does anyone have any questions?
Just one question from a participant back when you were talking about the forfeiture by wrongdoing hearing, and they're asking about the defense's knowledge about the letter that the victim sent in this case and whether or not that would be aware of once you filed a motion of disclosure with the PA, with the prosecuting attorney.
That whether we would notify them of the letter? Is that the question?
Yes. Wouldn't the defense have known about the letter if the defense attorney had filed a motion of disclosure with the PA, with the prosecuting attorney?
I would, as part of introducing all this, I would introduce this letter. Absolutely. Yes. So the defense will know. But again, when we think about the sequence of events, we know that the letter was sent by Albert after he returned from the preliminary hearing and found the note from Simon on his pillow. So absolutely, I would use that letter, and I would use it to show that there is a direct link between Simon's act of intimidation and Albert's expression that he does not want to participate in the trial.
Great. So far we don't have any other questions, but please, if you do have questions, let us know. And as Vicki had mentioned before, please feel free to contact either AEquitas or the PREA Resource Center with questions or comments. I did want to let you guys know that participants will be added to the PRC update list, so you'll receive those updates, and they send those out once every 2 weeks with additional information. Also, I know a couple of people are having technical issues. Just so you know, this webinar was recorded, so you can meant, and that link will be available on our training page as well as the PREA Resource Center's website shortly. So that'll be available for you to listen again. And if you have any more questions, we're going to stay on the line for a few more minutes. Please feel free to chat those questions to us. And thank you all again so much for attending today. You can also hang up the phone and leave the session if you're finished.
Thank you, everyone. And we hope to hear from you with any questions or concerns. Thank you so much.